Welcome to the Deep Dive, where we tear apart complex legal documents to find the surprising business insights buried inside. Today, we're diving into a question that sounds, well, incredibly niche, but carries a massive financial penalty for anyone offering hybrid services. When you give a customer an exempt service, what happens if a required follow-up service becomes necessary? Does the tax exemption cover the entire life cycle of that product?
It's the ultimate test of the fine print, really. And in this case, the stakes were huge. We're looking at a recent ruling from the European Court of Justice, case C8923.
Right.
It involves a Portuguese pawnbroker who suddenly faced, well, hundreds of thousands of euros in back taxes, all because the tax authority disagreed with how they categorized a single small commission.
Wow. Okay, so that's our mission today. To understand how the ECJ draws this razor-thin line between a single supply where everything shares the same tax treatment and distinct supplies.
Exactly. Where one element, even if it seems connected or even mandatory, suddenly becomes taxable on its own.
And that distinction is crucial, isn't it?
Oh, absolutely. Because for this pawnbroker, it determined whether an 11% fee they charge on an auction was VAT exempt, like the loan itself, or subject to the standard rate. A huge difference.
I mean, just imagine getting a $308,000 tax bill because the tax man decided your debt recovery process was a separate business entirely.
That's precisely what happened here. It's quite a shock.
Okay, let's start with the main player here. Companhia, União de Crédito Popular S.A., or CUCP. They're a Portuguese pawnbroking company.
Yep. And their core service is pretty straightforward. Granting loans secured by movable property, gold, jewelry, things people pledge.
And we know, based on EU VAT law, Article 135(1)(v) of the directive, that granting and negotiating credit is a financial service.
Correct. Which means it's VAT exempt across the EU. So the interest they charge, the principal itself, no VAT applies. That's their main business, their bread and butter.
The trouble, as it often does, starts when the money doesn't come back right.
Exactly. When a borrower failed to repay the loan or reclaim their pledged goods within the specified window, 3 months in this case, CUCP had to take action.
And they weren't just deciding to act. They were legally mandated by Portuguese law to hold an auction.
That's a key point. They had to auction the goods to recover the outstanding debt.
So this is where things get interesting tax-wise. When that auction happens and is successful, CUCP, the lender, earns a sales commission.
Correct. And Portuguese decree law, 806599, sets that commission at 11% of the auction price. Importantly, this fee is paid by the borrower, taken out of the sale proceeds.
Okay, so CUCP looked at this 11% commission and thought,
They thought it was all part of the same package. They treated it just like the interest and the loan itself part of the overall VAT-exempt financial transaction.
their logic being, we wouldn't even be holding this auction if we hadn't first granted the exempt loan. It seems connected.
It does seem connected, but the Portuguese tax authority, well, they saw it very differently. They essentially saw two separate business activities. They audited the books for 2010 and 2011 and concluded CUCP had failed to charge VAT on these auction commissions.
So they reclassified that 11% fee.
They did, reclassified it as consideration for a separate taxable service, not part of the exempt loan package at all.
And the resulting tax adjustment was substantial.
Oh, yes, over 107,000 for 2010 and over 201,000 for 2011.
Wow.
A total bill exceeding 308,000, just because of how that 11% fee was categorized.
That is staggering. 308,000 euro. It just highlights the risk, doesn't it?
It absolutely does. The financial peril lurking in these complex definitions, the line between exempt and taxable, can mean a huge unexpected liability.
Okay, so let's unpack the legal fight that followed. CUCP obviously contested this. What were their main arguments when it went to the Portuguese Supreme Administrative Court?
They had two main lines of argument. First, they tried a clever legal angle. They argued the 11% wasn't actually payment for a service.
What was it then?
They argued it was a statutory fee. Essentially, an unavoidable administrative charge mandated by law, not commercial consideration, subject to VAT.
Kind of like saying, the law makes us take this fee. It's not really a business transaction.
Exactly. Trying to take it outside the scope of VAT altogether.
Okay, that's one argument. What was the other?
Their second and probably stronger argument was that the auction was inherently inseparable from the VAT-exempt loan activity.
Ah, the single supply argument.
Precisely.
Yeah.
They argued the auction is the mechanism that makes the hold guarantee system work. You grant the loan because you have the security, and the auction is how you realize that security if needed. Therefore, it should share the VAT exemption.
That sounds logical on the surface. But EU case law makes this tricky, right?
Extremely tricky. The default position under the VA Directive, Article 1.2, is that every transaction must normally be treated as distinct and independent.
So you have a high bar to clear to prove two things are actually one single supply.
A very high bar. You have to show the elements are so deeply intertwined that they form one truly indivisible economic supply. Splitting them must feel artificial from the consumer's perspective.
Okay, now this brings us to the core legal test the ECJ uses, doesn't it? The famous ancillary test.
Yes, sometimes called the better enjoying test. This is the key criterion. For something to be considered ancillary, secondary, and inseparable, it must not be an end in itself.
Right.
Instead, it must merely be a means of better enjoying the principal service supplied.
Okay, wait a minute. If you're the borrower and you've defaulted and your stuff is being sold at auction, how is that possibly better enjoying the loan you took out?
Exactly. That's the inherent tension here. It sounds like the complete opposite of enjoying the service.
Right. It sounds like the worst possible outcome of the service.
And that's what the tax authority argued, citing previous cases like part service. They said the auction, the debt recovery, is absolutely an end in itself, at least for the lender. And it's certainly not something the borrower enjoys or sees as enhancing the original loan service.
What? There was this wrinkle with Portuguese national law, wasn't there? The fact that the law forced CTP to organize the sale.
Yes, that was the crucial nuance the Portuguese court flagged. Decree Law No. 36599 explicitly made CUCP, the lender, responsible for organizing the sale.
So the referring court wondered, doesn't that legal obligation automatically make the auction ancillary, inseparable from the main service?
That was the heart of the question sent to the ECJ. Does a state mandate forcing you to perform a recovery action automatically bind that action tax-wise to the original exempt service? Does it shield you from that $308,000 tax bill?
A lot riding on that interpretation. So the ECJ gets the referral. They weigh the state mandate against these core VAT principles. And they ultimately sided with the tax authority, right? The services were split.
They did. They ruled against the pawnbroker. The services were deemed distinct.
Let's walk through their reasoning, because these points are really the key takeaways for any business dealing with potentially mixed supplies.
Okay, first, we always have to remember the fundamental rule. VAT exemptions are exceptions.
So they must be interpreted.
Strictly.
Yeah.
Very strictly. CUCP needed more than just a strong link. They needed an inseparable one.
Got it. So reason number one for splitting the services.
Substantive independence. The ECJ looked at the core activity granting credit and asked, was that service dependent on CUCP also running the auction?
And the answer was?
A clear no. The ECJ stated the credit could have been provided in the same manner even if a completely different third party, say a professional auction house, had organized and carried out the sale.
But hold on, if the Portuguese law forces CUCP to organize it, why does the hypothetical possibility of outsourcing matter? That seems a bit theoretical.
It's about the economic nature of the service itself. The ECJ focuses on whether the service could, in theory, exist separately and be provided by someone else.
I see.
If it can, that proves it's economically independent, even if the law currently assigns the task to a specific party. The legal mandate dictates who performs the service, but it doesn't change the fundamental nature of the service as being potentially separate.
That's a subtle but powerful distinction. Okay, reason two.
This one relates to frequency and expectation. The auction is not an inherent feature or the usual outcome of a pawnbroker loan.
Right, most loans are repaid, presumably.
Hopefully. The auction is entirely contingent. It only happens if the borrower defaults for that specific period, 3 months. It's not like, say, providing account statements, which happens routinely.
So it's an exceptional event triggered by failure, not a standard part of the successful service.
Precisely. A truly ancillary service is typically part of the normal course of enjoying the main service. An auction triggered by default isn't that.
Okay. And reason three, this one seems to hit the better enjoying test head on.
Yes, this is about the distinct purpose. The ECJ said the purpose of the auction is clear. It's debt collection. It's enforcing the guarantee.
Whereas the purpose of the original loan was?
To provide capital. While they're financially related, the auction doesn't help the customer better enjoy the original loan service. Not at all.
It serves the lender's interest.
Exactly. It's a protective function for the lender. It is, in the ECJ's words, an end in itself. And that phrasing is critical. It immediately disqualifies it from being merely ancillary and sharing the exemption.
So essentially, the ECJ is saying the pawnbroker wears two hats here. The VAT-exempt lender and the a taxable auctioneer or debt collector.
That's a great way to put it. And finally, their fourth point directly addressed CUCP's initial argument about the fee being purely statutory.
Right, the attempt to take it outside VAT altogether.
The ECJ shut that down too. They confirmed the 11% commission compensates CUCP for the actual work involved organizing, promoting, running, and completing the auction.
So it's payment for a real service.
Yes. It's a consideration for a private commercial service, not just some administrative charge passed along. If you get paid to do something tangible that someone else could theoretically do, you're providing a service, and that service is generally taxable unless a specific exemption applies, which here it didn't.
Okay, so pulling it all together, the verdict is crystal clear. The ECJ found that organizing and running the auction is separate from granting the loan.
Correct. The auction-related supplies are not ancillary to the credit granting. They don't share the VAT exemption, and therefore they are separate taxable services.
So what does this case C8923 really mean for businesses listening? Obviously, pawnbrokers need to pay attention, but who else?
Well, this clarification is critical for anyone operating in a hybrid environment where exempt and taxable elements might coexist. We're not just talking financial services.
Give us some examples.
Think about, say, tech companies. They might bundle a software license, which is generally taxable, with long-term premium support. Is that support truly ancillary, or is it a distinct ongoing service potentially taxed differently?
Or universities.
Universities, yeah. Bundling tuition, often exempt, with compulsory student union fees or maybe special lab access, are those fees for separate taxable services or genuinely part of the exempt educational package? Insurance, healthcare, the list goes on.
So the big lesson here for businesses listening is about that link between services. It needs to be more than just convenient or even legally mandated.
It needs to be truly inseparable, not merely contingent on something going wrong like a default or being an optional add-on.
And if the secondary activity has its own distinct purpose.
Especially if that purpose is something like debt collection, enforcement, or realizing a guarantee.
Or if a third party could theoretically perform that function.
Even if the law currently makes you do it, the ECJ is very likely to split those supplies.
And demand VAT on that secondary part.
Exactly, which is why reviewing these structures is vital to avoid a massive, unexpected tax bill like the one CUCP faced.
It's fascinating. This deep dive into a pawnbroker's, well, predicament really shows how fine that line is, even in heavily regulated sectors. The difference between a financial guarantee mechanism and the core service itself.
Razor thin.
And potentially worth hundreds of thousands of euros in tax. The ECJ basically drew a line. The bank's job, the exempt part, ends when the loan is granted. The next job, acting as auctioneer, even if required by law.
That's a separate taxable business activity, different hat, different tax treatment.
So this leaves us with a final provocative thought for you, the listener.
Think about your own professional life, your own business operations. Where are you providing what you currently believe is an integrated, maybe exempt service?
But where one component is actually triggered by a specific event or has a distinct economic purpose, perhaps related to recovery or enforcement.
Is there an element that could theoretically be outsourced? Because the ECJ's logic suggests that mere possibility might be enough to signal a separate taxable supply hiding in plain sight.
Something definitely worth mulling over as you review your complex transactions and internal processes. You don't want that unexpected call from the tax authority.